Mom or dad are in a nursing home. You want to be able to make decisions for them. What do you need to do to have the ability to make those decisions? My name is James Kapralos. I'm an attorney at Waichman. In order to make decisions for a person, certain things have to be done. I'm going to go over a few of the ways that you could obtain decision-making abilities over a loved one. One of the ways to do it is to obtain a guardianship. Guardianship is a legal court proceeding where you petition the court or go into court in order to have the court grant you permission to make decisions for your loved one. Normally, when you have a guardianship proceeding, the person who you are seeking guardianship over has already lost their decision-making abilities. And the court will put into place a person who is able to make those decisions. This is a complicated process to which the court will determine whether or not you are qualified and whether or not they will give you the abilities to make decisions for mom or dad. Another way to do it is to obtain a power of attorney. One major difference between the power of attorney and the guardianship is that you do not have to go to court for the power of attorney. The power of attorney is signed prior to mom or dad losing their decision-making ability. Once mom or dad or a loved one or anyone else loses their decision-making ability, they no longer can sign a power of attorney. Power of attorney gives you the right to make certain types of decisions for the person who is giving you the power of attorney. There are different types of power of attorney. One of them is a durable power of attorney. A durable power of attorney allows you to obtain and retain the decision-making ability for the person even after that person loses their decision-making ability. If you don't have a durable power of attorney and later on the person loses their decision-making ability, you will also lose your ability to make decisions for them. So many times we suggest that clients have a durable power of attorney. Another document that you may want to have signed, and again, this is another one where you don't have to go to court, and this is one that you have to do while the other person you're seeking to make decisions for still has their decision-making ability, is a healthcare proxy. A healthcare proxy is signed giving you the right to make healthcare decisions for the person who is giving you that decision-making ability. The last document I would like to discuss is the MOLST form. The MOLST form is used in nursing homes. The MOLST form stands for Medical Orders for Life-Sustaining Treatment. This is a document that the nursing home will usually present to you, and there's a whole process that the nursing home must go through in order to pick the person who is able to make decisions for the nursing home resident. One of the things they must consider is your relationship to the nursing home resident and whether or not you know the nursing home resident's wishes. If you're able to satisfy that criteria, and if you're also able to satisfy a bunch of other things, you may be able to make decisions for your loved one even though you don't have a power of attorney or guardianship. If you're in a situation where you're wondering whether or not you would be able to make decisions for someone else in a nursing home, you may have questions. If you have any questions, pick up the phone and call me at the number below. I'll be happy to speak with you. I'm James Kapralos, an attorney at Waichman.